So thank you. Thank you everyone for being here. Welcome to Madrid, welcome to IE University, and welcome to the 10th annual conference of the International Society of Public Law. My name is Fernando Pastor, and I'm going to be your MC this evening. As you've probably seen in the program, we have a very busy schedule ahead of us, right? With the opening, the keynote speech, and then the first plenary panel of the conference. So I'll try to be brief and to keep the introductions rather short. Also because right after we are done here, there will be a small cocktail reception with some food and drinks waiting for all of us upstairs, sort of on the esplanade that is right in front of the tower's main entrance, basically where most of you did the check-in this morning. We'll guide you there once we're done, so no worries about that. Before we start, though, I'd like to say that we are really excited here at IE Law School to be taking over from our colleagues at Victoria, University of Wellington, who did a fantastic job organizing the previous edition of this conference. We are going to do our best, we are doing our best already to keep up to the high standards that they set last year. But of course, some things are necessarily going to be different, and one of them is the weather. As you may have noticed, the summer in Madrid can get really dry and really warm. So I, for one, I'm already missing the mild winter that we experienced in Wellington last year. It could get worse, so I guess we are being somewhat lucky, but I do want to ask everybody, sort of on a more serious note, to be careful, especially if you're not used to high temperatures. Of course, high temperatures are not going to be a problem so long as you remain within our building, within the IE Tower. We are really proud of our vertical campus, and we hope you enjoy the facilities and the views over both the city and the mountains. But of course, our vertical campus has certain drawbacks. One of them, as you've seen already, is that we are subject to strict safety regulations, which is why we need everybody to go through rigorous controls every time they enter the building. And the other drawback are the elevators. Sometimes at peak times, there may be queues and lines forming in the elevators. We've really done our best to minimize both problems, but we know that there will be occasional lines, occasional queues, occasional delays. And all I can say is just please come well in advance, especially if you're going to speak at a panel, and thank you in advance for your patience and understanding. Once you are inside the building, I think there's going to be plenty of staff and plenty of volunteers sort of helping you find your way around. And you're going to see many of them wearing T-shirts with the IE logo on it. They're over there, actually. Hi, guys. And I want you to notice them because these are our students. And I'm really proud of them because in most of our So in most of our programs, classes finished more than a month ago, and they've been generous enough to come back on campus to help us with the organization of this conference. I want you to notice them because they are here to help you, so please do reach out to them if you need anything. But I also want you to notice them because, in a way, they are our most junior colleagues at the conference, and I would like you to treat them as such. So please do engage with them, do reach out to them, and sort of make them feel and be part of this wonderful community. They are here to help you, but they're also here to learn from you and to profit from the feast of legal scholarship that ICONES conferences are always about. Finally, I want to say something about our sponsors, of course, which you will see on the screen in a second. The organization of an event of this size would obviously not be possible without the support of our sponsors, to whom we are extremely grateful. I want to thank, first of all, the research centers of IE that are supporting this event. That is to say, the IE Law Ahead Center on the Legal Profession and the Jean Monnet Center on Law and Automation. I also want to thank our partner universities and law schools, including NYU Law, University of Münster, and the Law Schools Global League. We also have among our sponsors many research centers affiliated with other universities, such as the Jean Monnet Center for International and Regional Economic Law at NYU, the Gilbert and Tobin Center of Public Law at UNSW Sydney and the Istituto di Ricerche sulla Pubblica Amministrazione in Italy. We have foundations like the Konrad Adenauer Stiftung and the Fundación Notariado, publishers, of course, Brill, Nickhoff, Edward Elgart, and Hart, and last but not least, the Spanish government, who is supporting the conference through the research grant on the strategic responsibility of member states within the European Union of the Ministry of Science and Innovation. To all of them, thank you. I hope I didn't miss anyone, but yeah, I don't think so. So really thank you. And please remember that Brill, Edward Elgart, and Max Planck have stands on floors 4, 10, and 16, so make sure that you pass by at some point during these 3 days and that you thank them in person. That's all on my side for the time being. I think we can get started with the opening ceremony. Our first speaker is Soledad Atienza, Dean of University Law School, to whom me and my colleagues are very grateful, of course, because she's the one who gave us the means to actually embark in this crazy adventure of organizing the 10th edition of ICON's annual conferences. I want to thank her for that, and I also want to thank her because actually the plan that we initially proposed to her and that she initially green-lighted was a conference for 900 people. And yet, here we are at the opening ceremony of the largest ever edition of ICON's annual conferences with more than 2,000 people registered and more than 1,600 people on campus today. So Soledad, it still blows my mind that I managed to convince you to do this, but thank you very much. The floor is yours.
Dear President O'Leary, President Hernandez Lopez, President Daoud Aboud, dear ICON's co-presidents Marta Cartabria and Richard Albert, dear ICON's members. This is a very important day for our university. We are extremely proud to host ICON's 2024 annual conference on the future of public law, resilience, sustainability, and artificial intelligence. Though now you know, as Fernando mentioned, that we expected less amount of members, we are extremely happy that all of you made it to Madrid and to IE. IE Law School is a global and multidisciplinary institution that transcends legal cultures, jurisdictions, and legal traditions. Our mission is to foster positive change through comprehensive research, innovative teaching, and through working together with private and public institutions, with law firms, and with companies around the world. We stand firmly behind our commitment to educate internationally minded legal professionals, lawyers, jurists, and citizens with a global vision of the practice of law. We are not the largest or the oldest law school, and I know many of the law schools represented here are older and larger than ours. But I can say today that we are one that makes a relevant impact in its community and in society. As the Spanish philosopher Adela Cortina has recently said, we need universities who work to transform society. Universities with a soul, universidades con alma. I am very proud to say that this is a law school with a soul. We wish to contribute to strengthening the links within the global community of academics and jurists in all areas of public law. And we believe some of today's greatest challenges, such as sustainability or artificial intelligence, are global issues that require a global legal approach and a multidisciplinary one. And they should be discussed and analyzed from a public law perspective. This is what this conference is all about. Our faculty, students, and staff have worked very hard to ensure that you enjoy the ICON's 2024 conference. Thank you very much. Fernando Pastor, Sergio Verdugo, Marie-José Gagot, Sonsoles Arias, Sara Junquera, Isabel Garcés, Yulila Kasparovich, François Deleroux, and Antonios Kourotakis. And special thanks for the support to NYU Professor Joseph Weiler. On behalf of all of us, welcome to iLaw School and enjoy the conference.
So, of course, we wouldn't be here today if it wasn't for the trust that ICONS, the International Society of Public Law, placed on us and on our project. So I would like to thank each and every one of the members of both the Council and the Executive Committee of ICONS, and in particular, co-presidents Marta Cartavia and Richard Albert. I want to say that it's been a pleasure to work with both of you and with your teams, with Sergio, with Micaela, and with all the crowd working for ICONS. It's been really a fantastic experience. And that's why I'm really happy to sort of call on stage Richard Albert, co-president of ICONS, and the William Stamps Farish Professor in Law at the University of Texas in Austin, which is going to deliver the welcome remarks on behalf of ICONS. Thank you, Richard, for being here.
Good afternoon. Welcome to the 2024 Annual Conference of the International Society of Public Law. On behalf of my fellow co-president, Marta Cartavia, thank you for being here, for making the journey to be with us today, whether you've come from far, far away or just down the street. If this is your first time here at the ICONS Annual Conference, welcome especially to you. We're delighted to have you. We look forward to meeting you, to getting to know you, and to supporting you in your goals. If you have been to our conference before, welcome back to each of you. We appreciate you, and we thank you for your continued support of ICONS. Soledad, Dean Atienzo, to you and to your entire team here at IE University, thank you for all you've done to welcome the world of public law here today at this great university, at this beautiful campus on this sunny day. Thank you for arranging the weather as well. I have just 3 short items to share with you today. First, a word about the mission of ICONS. Second, a word about a very special anniversary for ICONS. Finally, I will close with 3 requests for each of you. 3 requests. We gather here today in Madrid for 3 days of growth, connection, and collaboration. And we will do so together in the spirit of collegiality, encouragement, and affirmation. Let me invite you to look to your left and look to your right and look all around you. Each of you is part of the ICONS family. And it is because of you that ICONS is as vibrant and as diverse and as excellent as it is today. There is no other conference in the world like the ICONS Annual Conference, because there is no other learned society in the world like ICONS. It is the largest and leading learned society for the study of public law in the galaxy. ICONS was born with a 3-part mission to transform the field of public law. The first part, ICONS was founded to bring together scholars and practitioners, all persons interested in public law, broadly defined. This week, as you all navigate the halls and the elevators and the classrooms here at the conference, you will see students and lawyers and professors and judges all sitting together on panels and roundtables, discussing and debating the most important questions there are in public law with no regard for titles, and with mutual respect for all. The second part of the mission of ICONS is to break down barriers among disciplines. Here at ICONS, our members include scholars in all areas of public law, yes, but also across the humanities, the social sciences, the natural sciences, and beyond. And the third part of the ICONS mission is to serve the needs of early career scholars. We believe at ICONS that we are at our strongest when early career scholars are central participants in the life of the society. That's why ICONS is committed to giving early career scholars the support and encouragement they need to become excellent teachers and scholars, all with a view to enriching and enlivening the society and the field of public law more generally. These were the objectives our founders had when they created ICONS. Joseph Weiler, Sabino Kisese brought ICONS to life, and the mission they set for us all continues to inspire us today. Joseph, Sabino, thank you for all you have done for ICONS, for public law, and for us all. This is a landmark year for ICONS. 10 years ago, ICONS held its first inaugural mega conference in Florence. Since then, we've traveled the world, convening in New York, Berlin, Copenhagen, Hong Kong, Chile, Wrocław, Wellington, Santiago, and now here in Madrid. ICONS is thriving, and the state of the society is strong and growing ever stronger, and the proof is all around us here today and in the adjacent room. We are students and teachers and lawyers and judges, all of us interested in the values of public law. There are hundreds, thousands of us here, well over 2,000, and together we will sit on over 500 panels, and we have all come from over 80 countries around the world. The remarkable growth and success of ICONS would not be possible without each and every single one of you here. It's therefore appropriate to take a few moments to recognize the people on whose shoulders we stand, those persons who have made the mission of ICONS their own and shared it with the world. Let me invite you, if you are able, to please stand so that we can acknowledge you for your contributions to ICONS. If you are a member, past or present, of the ICONS Executive Committee, please stand if you're able so we can thank you. ICONS Executive Committee. Thank you. Thank you. If you are a member, past or present, of the ICONS Governing Council, please stand if you are able so we can thank you. If you are a member, past or present, of the ICONS Secretariat or an ICONS committee or subcommittee, please stand so we can recognize and thank you. Please. And I assume we'll have a lot more people standing now. If you are a member, past or present, of an ICONS national or regional chapter, please stand so we can thank and recognize you. Thank you for all each of you has done and what you'll continue to do for ICONS. We appreciate you, we value you, and we celebrate you. And now, before I close, I have 3 requests for each of you, for everyone in the room. I assure you it will be easy to grant these 3 requests. And the best part of all is that if each of us does these 3 things, it will enrich our community and it will enhance our collective experience here at our 10th annual conference of the International Society of Public Law. So 3 requests. First, if you see someone standing alone or eating alone, please go introduce yourself to that person and invite that person to join your group, because that person is a member of our ICONS family. Request number 1. Second, if you ordinarily fully immerse yourself in one single subject in public law, please give yourself the opportunity to learn about something completely brand new. Please go to a panel that falls into an entirely different subject than the one you know best. That will reveal to you the true intellectual treasure of being a member of the ICONS community. And third, if you are a longtime member of ICONS and you've attended a conference before, please seek out first-time conference attendees and welcome them into our family. Let them know how much we appreciate and welcome them and how much we are so happy to have them here. And this goes not just for those who are repeat attendees, but every single one of us. Let's make this conference not just the intellectual academic feast that it is, but an opportunity for personal growth and networking and fellowship among us all who care about the values of public law. So thank you. Thank you to each of you for being here, and thank you once again to our hosts. Fernando, thank you for moderating this session. May we all enjoy our time together over the next 3 days in what I'm certain will be an academic feast unlike anything we have ever experienced before. Welcome to the 2024 ICONS Annual Conference.
Thank you, Richard. I think we can move on and welcome our keynote speaker, Shifra O'Leary, who recently stepped down as a judge of the European Court of Human Rights after 9 years of service, the last 2 ones as president. We are really grateful that you accepted our invitation to be here with us, despite the fact that these are probably hectic days of change for you. And it makes us and it makes me very happy, because I cannot think of a better way to celebrate your important contribution to human rights protection in Europe and beyond. In line with the theme of the conference, the title of the keynote speech is going to be Human Rights in Times of Trouble, Some Reflections on Sustainability and Resilience. Please join me in welcoming on stage former President Shifra O'Leary.
Dean and Vice Dean of IE, members of ICONS, buenas tardes a todos. It's a real honor to be invited to your 10th annual conference and to have been asked to deliver this keynote speech. The size and nature of today's conference could make a jurist feel like they're speaking to the legal equivalent of the Bernabeu. But for those of you who follow Spanish football and out of family loyalty, for me, it's like speaking in the Sanchez Pizjuan. You're all here to discuss the transformations which public law is undergoing as a result of some of the major societal challenges of our time. Given the recent judicial output of the European Court of Human Rights, in which I served, as you just heard, as a president until last week, I propose to concentrate on a topical aspect of sustainability, and specifically the role of courts in the global effort to fight climate change. I'll then touch on a broader issue, namely the role of different members of the legal profession, from courts to lawyers and members of civil society, in the quest for much-needed resilience in these troubled times. To explain the choice of title, allow me just for a few minutes to place my 9-year judicial mandate just served in its context. When I arrived in Strasbourg in spring 2015, formations of French soldiers were already patrolling the streets. The bloody attack on the Charlie Hebdo magazine having cost 14 lives a few months previously. Further brutal terrorist attacks were to follow in the immediate and subsequent years in Paris, Nice, Brussels, Manchester, and in Strasbourg itself. The army patrols fluctuated from 3 to 5 to 7 soldiers, dependent on the risk assessment at any one time. I have to admit that as an Irish woman who grew up in Ireland in the 1970s and 80s in what we in Ireland called the Troubles, I didn't expect to be greeted on the picturesque streets of Strasbourg by scenes reminiscent of Belfast or Newry. 2015 was also the year of migration, with over 1 million people seeking European refuge, many by sea and many never making it to Europe's shores. 2016 then brought Brexit and a change of regime in the US, with significant consequences, I think we can fairly say, then and now, for multilateralism. It also brought an attempted coup d'etat in Turkey, with lasting effects for that state, but also for the Council of Europe. A global pandemic was not, of course, far behind, bringing with it a host of societal, political, economic, and legal challenges whose consequences are still being felt today. And then came war. For the residents of Ukraine, the war which continues to be waged today started not on the 24th of February 2022, but 8 years earlier in Crimea. But other conflicts, let's not forget, have kept simmering in Europe, in Nagorno-Karabakh or in Transnistria, to name just a few. And meanwhile, in the Middle East, the brutal attacks of October 7th last have sparked military action, resulting in massive loss of life and destruction, witnessed daily on our screens. And these events now test the jurisdiction of other international courts, but they also test the commitment of states to the international treaties to which they sovereignly subscribed. Natural catastrophes, albeit ignited by humans, quite literally, or whose impact may have been heightened by them, have given rise to death and destruction throughout this period. Take, for example, Greece in 2018, or Turkey in 2023, where over 53,000 people perished and 3 million remain homeless. And throughout this time, in certain European states and beyond, judicial reform, which in itself is entirely legitimate and necessary, became a pretext for measures to limit independence of national judges and therefore to stymie their crucial function in national EU and convention frameworks. So when I chose as my title, Human Rights in Times of Trouble, and my apologies, I know this is a global conference, for the Eurocentric nature of the contextual overview which I just provided, I felt it fitted entirely the judicial period just served. The Strasbourg Court sits at the center of what I would describe as a fragile, but nevertheless very resilient web, serving for almost 70 years a legal space which now covers 46 states, 46 legal orders, and 46 court systems, inhabited by over 700 million potential individual applicants to the Strasbourg Court. And it's no exaggeration to say that all of the events that I've just described manifest themselves in one form or another on the Strasbourg docket. This can sometimes be to the tune of thousands of individual applications. Think of the influx of cases in relation to the Turkish authorities' response to the attempted coup d'etat I just referenced, or the over 20,000 applications lodged in the space of just a few weeks to challenge the French government's introduction in 2021 of a COVID pass. And in the words of one of your members, Professor Hellbrunner, in an Icon guest editorial from 2019, and I quote, "Since 2015, things have happened, mostly not good." I'll return to that prescient editorial in my closing section on resilience. But turning first to sustainability, few cases have attracted more global attention to Strasbourg in recent years than those which culminated in the 3 climate change rulings which we handed down last April. Professor Sharpston and my judicial sisters from the Inter-American Court and the African Court will forgive me if I trespass into the subject of our plenary panel, but it would have been impossible to frame this keynote without tackling these rulings. Those of you present who are familiar with European Union law will be familiar with groundbreaking EU judgments like Van Gendenlos or Costa and Enel. And in recent years, legal historians have mapped how judges from that court, the Luxembourg court, and registry staff took to the road in the 1970s to explain, clarify, and sell those groundbreaking judgments. I mention this because as the presiding judge in all three cases, I can certainly explain or seek to clarify them, but I'm not here to sell them to you. It's far too early, despite what some commentators claim, to judge what the impact will be of the Strasbourg Court's climate change contribution. Time alone determines if court rulings are true landmarks. In due course, the European Court of Human Rights, as we'll explain in the plenary, will have to apply the general principles it established in those three rulings. And in due course, convention complaints raised before national judges will require a convention-compatible response. And it's important for me as a former president not to trespass into future judicial work. Whether as judges, lawyers, law professors, citizens, climate warriors, or climate deniers, you are free to agree or disagree with both those rulings or any of the other thousands of judgments and decisions handed down by the Strasbourg Court. But my principal job, now as a convention champion, is to ensure that whichever way your opinion falls, that opinion is informed, understands the cases, the context, and the convention. The significance of the recent rulings cannot, however, be denied. If nothing else, the reaction in 1 or 2 quarters has highlighted how easy it is to scapegoat foreign judges these days, or how simple it is to characterize the complex interpretation and application of the law by judges as trespass into the parliamentary domain. One paragraph alone, however, paragraph 436 of the judgment in Klima, that's the Swiss case, demonstrates the general importance of these rulings, whatever the legal future brings. In it, the court made clear that it proceeded on the basis, and I quote, "There are sufficiently reliable indications that anthropogenic climate change exists and that it poses a serious current and future threat to the enjoyment of human rights guaranteed under the Convention." The rulings thus showcased the existing and abundant climate change science, and as other national courts had done so previously, it conferred on that science the imprimatur of judicially recognized fact. Today, I'd like to highlight just some key takeaways from the 3 rulings. The Grand Chamber, which is composed of 17 judges, coordinated the processing of the 3 cases and delivered the rulings on the same day. And as members of ICON, you know that this was entirely deliberate. So it's therefore important to approach the judgment, which found a violation or 2, but also the 2 inadmissibility decisions as a trilogy. The essence of the complaints in all 3 cases was that state authorities had failed to respond adequately to combat the effects of climate change. The applicants, senior Swiss citizens, an environmental association, a former French mayor, and a group of Portuguese children who then became teenagers, framed their complaints with reference to Articles 2, 8, and 6 of the Convention, which relate to the right to life, to privacy and home life, and to access to court. Over time, the Strasbourg Court has developed extensive case law under Articles 2 and 8 of the Convention in the environmental field. For well on 4 decades, it has repeatedly held that while none of the articles of the Convention is specifically designed to provide general protection of the environment, the responsibility of state authorities in this area should in practice result in their intervention at the appropriate time in order to ensure that the statutory provisions enacted with the purpose of protecting the environment are not entirely ineffective. Leaving aside interstate cases, of which there are 13 currently pending before the Strasbourg Court, these cases are of a different nature, the Strasbourg Court deals with individual complaints introduced by individual persons or groups of persons as a result of state action or omissions which affect them directly or in certain circumstances indirectly, whether actually or in rarer cases potentially. The justice sought and delivered is in essence individual, even if judgments and decisions can have far-reaching collective and societal effects. As explained by the court in the preliminary observations in the Swiss case, Klima, in these 3 climate change cases, Europe's regional human rights court was being asked to enter unchartered convention territory, where it faced legal questions in relation to admissibility and merits, some of which didn't find an obvious response in the existing case law. The court emphasized that it can deal with human rights issues resulting from climate change only within the limits of the exercise of its competence under Article 19 of the Convention. It confirmed, as I mentioned the previous case law, that no Convention article is designed to provide general protection of the environment. But the court also stressed that the adverse effects of climate change primarily require legislative action, which necessarily depends on democratic decision-making. For the Strasbourg Court, the central position of national and EU democratic decision-makers tempers the nature and extent of judicial involvement, but it doesn't exclude it. But what was the Convention law to be applied as regards the specific and different issues raised by climate change? The court noted that while an important source of inspiration and guidance, the existing and abundant environmental case law wasn't directly transposable, as there are critical differences between climate change and classic environmental cases. The existing case law principles therefore needed tailoring as regards the various Convention issues which were being raised. In addition, the court stressed that it only has authority to ensure that the Convention is complied with. Its jurisdiction doesn't extend to the supervision of compliance with other international treaties or obligations. But this doesn't render those other international treaties, such as the Paris Agreement, irrelevant. Such instruments represent both international consensus in the field, but they also reflect the requirements and commitments to which Convention states have undertaken to respect. One of the important developments in these rulings is the court's acknowledgement, for the first time and in the climate change context, of the relevance of intergenerational burden sharing. In Klima, the court expressly stated that future generations are likely to bear an increasingly severe burden of the consequences of present failures and omissions to combat climate change. It also recognized that they are at a representational disadvantage in the relevant current decision-making processes. However, it is worth stressing that the intergenerational burden sharing formed part of the justification for the fact and nature of the judicial review exercised. It didn't constitute a self-standing reason for the creation of new rights for persons not before the court or not even alive. As many of you know, the Strasbourg Court interprets and applies the European Convention in an evolutive fashion and in the light of present-day conditions. This characteristic of the 70-year-old Convention has proved of fundamental importance in maintaining its relevance and reach for over 7 decades. However, the Convention is also an instrument which is interpreted and applied by judges who must remain within the constraints of their judicial function. The court proceeds generally, and it proceeded in these cases more incrementally and prudently than some of its critics, including the sole dissenter in the Swiss case, conceded. The living instrument document, the principle of evolutive interpretation, and the court's examination of international materials emanating from scientific and policy bodies made it impossible to disregard the pressing scientific evidence and the growing international consensus regarding the critical effects of climate change on the enjoyment of human rights. This general finding, however, is offset by many modulators of the Convention's role and its limits, which are to be found in the nuts and bolts of the 3 rulings. Under the Convention, jurisdiction is, of course, a threshold issue. It must be resolved before the Strasbourg Court looks at any other issue. And jurisdiction of high contracting parties under Article 1 of the European Convention is principally territorial. Extraterritorial jurisdiction, as those of you who are experts in the field, is possible, but it remains exceptional. It can be established with reference to effective control by the state over an area, or state agent authority and control over individuals. It's important to stress that the court acknowledged several special features of climate change litigation which had been relied on by the Portuguese teenage applicants in what's called the Duarte case. Firstly, it recognized that states have ultimate control over private and public activities based on their territories that produce greenhouse gas emissions. Secondly, albeit complex and multi-layered, there is a certain causal relationship between public and private activities based on the state's territories that produce greenhouse gas emissions and the adverse impact on the rights and well-being of people residing outside their borders. And thirdly, the problem of climate change is of a truly existential nature for humankind, in a way that sets it apart from other cause and effect situations which the court had previously examined in relation to claims for extraterritorial jurisdiction. However, the court found that these considerations could not, in themselves, serve as a basis for creating, by way of judicial interpretation, a novel ground for extraterritorial jurisdiction. In particular, the court rejected the applicant's submissions to the effect that control over the convention interests should serve as the relevant test for establishing jurisdiction in the field of climate change. The court considered that such an approach would entail an unlimited expansion of the state's extraterritorial jurisdiction under the convention and responsibilities thereunder towards people practically anywhere in the world. The case against the 32 states other than Portugal in the Duarte case failed on this jurisdictional basis. And those of you familiar with the decision of the Committee of the Rights of the Child in a case called Saki and others will of course note that Europe's Regional Human Rights Court took a different approach to transboundary harm related to climate change than that committee, which had in turn followed the Inter-American Court of Human Rights. In order to seek protection before the Strasbourg Court, individuals need to show that they are affected by the actions or omissions of one or more of the contracting parties to the Convention. The Convention doesn't recognize actio popularis, and there's thus no possibility to institute Convention proceedings to ensure protection of a general cause or to seek abstract review of domestic law and practice. The actio popularis restriction doesn't, however, exclude actions of a collective nature. In Klima, one of the main obstacles for the individual applicants, otherwise known in the press as the Swiss grannies, related to the question of victim status. As explained by the court, and I quote a short extract, if the circle of victims within the overall population is drawn in a wide-ranging and generous manner, this would risk disrupting national constitutional principles and the separation of powers by opening broad access to the judicial branch as a means of prompting change in general policies. But if, on the other hand, this circle is drawn too tightly and restrictively, there is a risk that even obvious deficiencies or dysfunctions in government action or democratic processes could lead to the convention rights of individuals and groups of individuals being affected without them having any possibility of judicial recourse. In relation to the individual victim status alleged by the Swiss seniors, the court established a high threshold tailored to the climate change context, but it was also clearly aware of the floodgates possibility and mindful of the Convention's exclusion of actio popularis. Its two-tier test requires applicants to demonstrate that they fulfill distinguishing criteria, namely high intensity of exposure to the adverse effects of climate change and a pressing need to ensure the applicant's individual protection. The applicants in the Klima and Karem cases were found not to have fulfilled these requirements. In the Swiss case, the degree of intensity of the risk posed by warmer Swiss summers didn't meet the relevant threshold. But in the French case, the applicant mayor no longer resided in the affected region, nor indeed did he reside in France, having become a member of the European Parliament. However, the Swiss case presented the court with an additional question. Could the applicant association enjoy victim status or standing? The Swiss courts hadn't examined this issue at all. They'd just concentrated on the individual applicants, and they had rejected their complaints as being actio popularis. And in the past, the court has emphasized, specifically in a Spanish case, Goraiz Lizarraga, and I quote, in modern-day society, when citizens are confronted with particularly complex decisions, recourse to collective bodies, such as associations, is one of the accessible means, sometimes the only means, available to them, whereby they can defend their particular interests. One of the main innovations in the Klima judgment, but which nevertheless finds strong support in existing case law and the European consensus, is to grant standing, provided certain conditions are met, to collective entities to defend the rights and interests of affected or concerned members and individuals. And I'll touch on the possible consequences of this for EU states after touching on the next key takeaway. Because at the heart of all three climate change rulings is the importance of access at national level to independent and impartial courts and effective national remedies. The court stated in Klima in relation to the Article 6 complaint relating to access to court, showing the overlap between questions of victim status, causation, and the applicability of Article 6, the court held where future harms are not merely speculative, but real and highly probable or virtually certain in the absence of adequate corrective action, that the fact that the harm is not strictly imminent should not on its own lead to the conclusion that the outcome of the proceedings would not be decisive for its alleviation or reduction. Such an approach would unduly limit access to court for many of the most serious risks associated with climate change. In the climate change context, the court considered that the legal actions of associations must be seen in the light of their role as a means through which convention rights of those affected by climate change, including those at a distinct representational disadvantage, can be defended. In the Klima case, as you probably know, the court found a violation of Article 6 since there was no avenue under Swiss law through which the climate change complaints of the applicant association could be brought before a court. The Klima judgment applies to all 46 Council of Europe member states, but as one commentator has emphasized in relation to the access to justice strand, the EU 27 may need to pay particular attention. And this is because of the mirroring of convention rights in the EU Charter, but also because of the EU's extensive regulatory framework of relevance directly or indirectly to climate change. Given strict standing requirements for direct actions under EU law, the question which may arise, and as a former judge I emphasize may arise, is whether EU law provides associations and NGOs with effective remedies to challenge inadequate climate change action. Moving finally to the positive obligations identified by the court in the climate change context. Let me bring you back 45 years ago. In a case called Airy against Ireland on access to court, the Strasbourg court relied on the living instrument doctrine, and it recognized, and I quote, fulfillment of a duty under the convention on occasion necessitates some positive action on the part of the state which cannot simply remain passive. And so, 45 years ago, the convention's positive obligation doctrine was born. The content and scope of those positive obligations in the context of climate change have now been defined in the Klima judgment, in which the court preferred to examine the case from the perspective of Article 8 instead of Article 2. The court relied on the well-established principle according to which states have a duty to adopt and to effectively apply in practice regulations and measures designed to provide effective protection of human life, well-being, and health. This may sound groundbreaking, but the court's Article 8 environmental case law had required proactive risk management for many years. And as to the margin of appreciation, the court made a distinction. The state's commitment to the need to combat climate change and the setting of the requisite aims and objectives calls for a reduced margin. But as to the choice of means, the Strasbourg court made very clear that the margin enjoyed by the states has to remain wide. The court went on to distinguish between three types of measures: mitigation, adaptation measures, and procedural safeguards, all of which would be examined in order to see whether the state had stayed within its margin of appreciation. But ultimately, the obligation imposed consists of an obligation of due diligence, with the states left to determine the means necessary in their jurisdiction to fulfill the convention requirements. In extracting and structuring the key takeaways from the three Grand Chamber rulings, I have, to a certain degree, sought to fulfill the opposite mission to that undertaken by the Court of Justice members in the Van Gendenloos Roadshow. My aim has been to emphasize the convention orthodoxy of most of what you will find in these rulings in relation to exhaustion, subsidiarity, the margin of appreciation, the due diligence core of the positive obligations, and the continued prohibition of actio popularis. Running through the court's three rulings and its relevance for your discussions on sustainability, is a fair and appropriate balance in 2024 between judicial protection of human rights seriously affected by the effects of or failure to tackle climate change and democratic policymaking. And of course, some of you and some outside of this building may disagree. To conclude this section on sustainability, it may be ironic that it was not in the case brought by the young Portuguese nationals, but in the case brought by the Swiss grannies, that the convention relevance of intergenerational burden sharing in the climate change context was recognized. But therein perhaps lies the essentially interconnected legal nature, and might I say, as a former judge, the legal beauty of human rights litigation, as reflected in 3 generations of right holders mingling in Europe's human rights building on the 9th of April last. Turning to the subject of resilience, it's difficult to limit to the time remaining the numerous examples of convention case law which speak to the basic objective of the convention to ensure democratic and rule of law resilience at national level. The European Convention Court has delivered thousands of judgments on fair trials, freedom of expression, assembly, or free elections, not to mention many more thousands of judgments on human dignity, whether protected by absolute or qualified convention rights. I'll limit myself, and I'm going to reduce my 2 examples to just one example from the case law. The case I want to mention is a case called NIT against the Republic of Moldova, delivered by the Grand Chamber in April 2022. It concerned the freedom of expression of a television channel, which following elections became a platform for not just criticism, but virulent criticism of the new government. It was sanctioned for serious and repeated breaches of the legal obligation under Moldovan law to ensure political balance and pluralism. Its broadcasting license was eventually revoked. And this case raised novel issues relating to the internal dimension of media pluralism, the openness of discourse in European democracies, and the right balance to be struck between safeguarding political pluralism and respecting editorial freedom. The court found no violation of Article 10 and Article 1 of Protocol 1, the right to property, in the particular circumstances of this case. It held that when states such as Moldova opt for a regulatory model requiring internal pluralism designed to guarantee balanced political coverage, this was found to fall within their margin of appreciation. It reflected not just their political culture, but also the historical development of their broadcasting sector. The role of the Strasbourg court in a case like this is to ensure that the effects of the regulatory regime a state chooses are compatible with the guarantees afforded by Article 10. And the scrutiny the Strasbourg court exercise will be more or less strict depending on the degree of restriction or interference with freedom of expression. The existence of procedural safeguards was underlined as being absolutely essential, but so too is the role of the regulatory authority, whose independence has to be verified, given the delicate and complex nature of that role, as demonstrated in the NIT case. But interestingly, this Strasbourg judgment was quickly picked up by the General Court of the EU. It was faced with an annulment action brought by RT France against the EU Council legislation imposing sanctions following the invasion of Ukraine, and the annulment action failed. But I mention these judgments because of the finding of no violation or the refusal to annul. These are signs, if a sign is needed, of the changing landscape in which we're working and the measures which now may be considered necessary in a democratic society to ensure the resilience of democratic societies given that changed landscape. Turning the spotlight away from judges, whether national, regional, or international, I'd like to close this section on resilience by instead turning the spotlight on you, as legal professionals who have all lived through the various annus horribilis, which we've characterized the last decade, if not the last 2 decades. Few Irish public speakers resist a reference to one of our Nobel laureates, the poet Seamus Heaney, and I'm no exception. Few jurists can resist the compelling nature of poems like The Republic of Conscience, written in 1985 at the request of Amnesty International, or The Cure at Troy. I recommend them both after the conference. But less well known is a piece by Heaney, written in 2009. In line with his long-standing commitment to questions relating to justice, reconciliation, and respect for human rights, he gave a lecture entitled Writer and Writer, that's with a W and with an R, at the Irish Human Rights Commission. Celebrating the now 75-year-old Universal Declaration, he evoked writers and poets through the ages who had addressed, and I quote, they'd addressed themselves to matters of public concern, to the res publica, to the cruelty of regimes and the oppression of nations and people. Here in Europe, the onset of war in its more blatant form in 2022 woke us up from a long slumber. It stirred, in some at least, or in many at least, for some too fleeting a time, a sense of responsibility to act to uphold human rights, and generally to pay more attention in order to protect what Heaney referred to as the immunity of the body politic. This brings me back to the Heilbronner editorial from 2019. If she's here, I hope she doesn't mind me using her words. In that editorial, she rightly asserted that the core of academic freedom is and must remain the freedom to criticize, to pursue moral causes and oppose injustice as academics see it. But it's her final passage which stayed with me in my work as a judge, albeit a judge not a stranger to academia. She wrote as follows: academic freedom is not merely the duty to criticize and let the world make of it what they will. Lawyers and academics, no less than judges, shape the institutions of law. They take part in lawfare, whether they want to or not. Catchy phrases and shocking critiques may win admirers and gain attention, but they also may provide ammunitions for goals quite different from their author's intentions. If those who attack institutions have weighed the costs, fair enough, but I worry that they do not always do so, or do not do so with a gravity to match the risks. End of quotation. Your academic and professional freedom is absolutely vital to improving judgecraft. Seeing well-reasoned criticism of judgments in which one has either concurred or dissented, or others in which one hasn't sat, is a useful, if not essential, filter for a judge to consider, reconsider, check, and recheck the judicial trajectory chosen, or the jurisprudential impact of a given ruling, or the lack of impact of that ruling. But I would be a rich woman if I had bagged €1 for every time I read, in relation to one judgment or another, that the Grand Chamber in Strasbourg or a smaller composition had missed an or the opportunity. A unanimous 17-judge violation judgment can provoke such a response, in the same way as a split chamber, 4-3, finding a violation or no violation. If the preferred outcome of the academic commentator is not reached because of a failure to comply with admissibility requirements, those requirements are sometimes derided as unnecessary, arbitrary, or unfair. Judicial time devoted to one issue, say climate change, may offend the sense and sensibilities of those whose research is devoted to another area, say interstate conflicts. Months may go by when no commentaries are published on what are, by any measure, key cases and judgments, while niche areas attract extraordinary amounts of ink. Make no mistake, judges, particularly in separate opinions, can serve up this type of lawfare too, without reflecting on the impact on the authority of the court to which they belong their concurring or dissenting opinion may have. Courts, including international courts, can also miss opportunities by being unnecessarily hermetic and perhaps even territorial when a more open approach to the influence of other courts and their jurisprudence might greatly benefit not just the work of the courts in question, but more importantly, the common legal question on their tables. I don't think I'm alone in noticing that the recent ITLOS opinion on climate change omitted all reference to the Strasbourg Court's climate change rulings, despite those rulings quite clearly having been in the deliberation room according to 2 dissenters. However, we are jurists all. Is it not worth reflecting back on the last decade and considering as judges, lawyers, law professors and jurists, what have we done and what have we failed to do? With and to whom are academics speaking nowadays? What is the impact or purpose of catchy phrases and shocking critiques? Is enough being done to fact-check, unpick misinformation, respond to what I would refer to, and you can disagree, as pseudo-scientific critiques, and reveal what funding lies behind pseudo-scientific critiques? Is there enough engagement with the press in a manner and at the moments required? Judges and courts cannot respond in real time. They are best left speaking through their judgments and decisions. So is it worth contemplating more or different media engagement? Have academics fallen out of love with teaching? I noticed that this is a subject of one of the panels. If so, remember the intergenerational theme and your role, your crucial role in that regard. In my 9 years at a regional human rights court, which has been under immense pressure politically, in terms of case management, and regards it's what I would refer to as entirely inadequate budget, I have only once, in a blog published 2 weeks ago, seen an academic refer to the very limited resources at the disposal of a court with over 64,000 cases pending. There are, of course, shining examples of engaged responses to this decade of decline. I come from an island which laments still the effects of Brexit on all concerned, and I have just emerged from an institutional position in which I have had to engage repeatedly and very carefully with the neighbouring authorities in the UK to clarify why the miracle of the European Convention on Human Rights should not be forsaken. Because of my geographical origins, I can particularly recommend the work of Joelle Grogan and Alice Donald, for example. But of course, I know there are many of you in the audience who engage in the same, and as a former judge, I would please plead with you, please continue to do so. You have the voice that we as judges don't have. Resigned to, but I hope that that's not the case, some of you misunderstanding my call to more considered arms, I leave you with an extract from a relatively recent Strasbourg judgment on Article 10. I think in 2024 it speaks for itself. The case is Godenow against Germany. It's a case relating to the blacklisting of a teacher from German state candidate lists due to extreme political views. The court emphasized in that case as follows, and I quote, "The enormous importance from a public policy perspective of teaching and educating in a credible manner about freedom, democracy, human rights, and the rule of law. We should ensure that the next generation of jurists and judges are critical thinkers, capable of seeking change where change is needed. But in the process, please, with a capital P, do not forget to consider what we desperately need now to support, to bolster, and preserve." I thank you very much for your attention.
So thank you so much for delivering this relevant, topical, and thought-provoking keynote speech, which connects so well with the first plenary panel of the conference on sustainability, climate change, and human rights. Before I introduce the panel and before I hand it over to the very distinguished speakers of the panel, I'd like to give the floor to Isabela del Alcázar. I think Isabela del Alcázar is one of the few non-lawyers in the room, although she's well-versed in environmental law and governance, because besides being a biologist, she is a leader in science and sustainability. She's here to open the first plenary panel on sustainability, climate change, and human rights in her capacity as Chief Purpose and Sustainability Officer at IE University. Isabela, thank you for your support. Thank you for being here.
Thank you. So, ladies and gentlemen, good afternoon to all of you. Actually, it's an honor for me to be here. As Fernando was saying, I think I'm the only biologist around. So, and basically, being in the middle of all of this amazing and remarkable women that we have with us today. And I do think that this conference today exemplifies the transformative power of education and the role we have as universities in shaping individuals, which at the end of the day will be capable of changing this world for the better. So the role of us as universities and many others that are here that come from the academia also in developing these competences that drive global change cannot be overstated. We, I mean, all of us, but the role of universities, we serve as crucibles of knowledge, fostering critical thinking, as Professor O'Leary was saying, innovation, and a deep understanding on societal issues, which is, it's crucial for us here to give a context on the why we are teaching inside the classrooms. No? We have to prepare our students for the workforce, but also to lead, to inspire, and to enact this meaningful change. So we just heard from Professor O'Leary, and we will be hearing in a few minutes from Presidents Abud and Hernandez, together with Professor Sharpstones in the panel. And we will learn that we will learn from them, and I'm sure that their contributions and their efforts should inspire us and incentivize us to continue fostering interdisciplinary learning, which is key, and also encouraging this global perspective. At iUniversity, we know that we must prioritize not only excellence, the academic excellence, but also the development of ethical leaders who are committed to justice and human rights. We need to have this purpose at the top of our minds. We understand it this way here at our universities, and this is why behind what sometimes seem like ordinary tasks, like organizing an event, having these amazing speakers with us, inviting the audience and having you all here, behind these ordinary tasks lies a much deeper drive, which is basically bringing light to a world which is in disarray. We heard right now some of the causes of this disarray, and also a world that is in permanent change. We know that the transformative power of a university lies in our ability to inspire these individuals that can trigger a chain reaction of positive change. By investing in education and fostering environments where critical thinking and innovation thrive, universities like ours, like many of yours, can continue to produce leaders like our esteemed invited speakers and panelists who shape a better and more just world. So thank you very much, and I hope you enjoy.
Thank you again, Isabella. And I would like now to call on stage the chair and the speakers of the plenary panel. You can sort of start making your way on stage whenever you're ready. I think we have a truly stellar lineup of speakers for the next plenary panel on sustainability, climate change, and human rights. Shifra O'Leary, whom I introduced before, is of course one of them. She's going to be joined on stage by Justice Nancy Hernandez, who was a justice at the Supreme Court of Costa Rica before being appointed as judge at the Inter-American Court of Human Rights, where she now serves as president. Thank you very much for being here. Muchas gracias. We are also lucky to have with us Lady Justice Imani Daoud Aboud, former judge at the High Court of Tanzania and current judge at the African Court of Human and People's Rights, an institution that she has been leading as president since 2021. Thank you, President, for being here. And last but not least, Professor Eleanor Sharpston has kindly accepted to moderate the panel. Professor Sharpston served as Advocate General at the Court of Justice of the European Union from 2006 to 2020. She was the last British Advocate General at the Court of Justice before Brexit, and Brexit notwithstanding, she left a long and strong imprint on the case law of the European Court of Justice, in particular through her masterful opinions in some of its landmark human rights cases. She is now visiting professor at Cambridge and a member of the Aarhus Convention Compliance Committee. Thank you, Professor Sharpston. I hand it over to you, and thank you, Presidents O'Leary, Hernandez, and Daoud Aboud for being here.
Ladies and gentlemen, good afternoon to you all. And I would like to thank President O'Leary for a wonderful keynote speech, which I now have to try to interweave with the topics that we are dealing with in this plenary. Now, with the agreement of the ladies sitting with me, I am not going to do a detailed introduction of each of these learned sisters. We have already had an introduction from the Master of Ceremonies, and I know what you actually want to hear is the discussion rather than a recital of people's curricula vitae. I am also going to follow the polite convention of my native land, and therefore, despite the fact that President Schieffer O'Leary is now former President Schieffer O'Leary, I am going to refer to all these three ladies, two serving and one former president, as presidents, which is only right and courteous, I think. So, I'd like to begin by just helping us all to get a bit of a feeling of where the different jurisdictions have got to in terms of whether they are faced with litigation involving human rights which is aimed at promoting sustainability and or combating climate change. Now, President O'Leary, you've obviously mentioned the three very big cases that your court has recently dealt with, but I think there's some other cases which were in the pipeline, which were put on hold while you were dealing with those cases, and perhaps you'd like just to mention those briefly, if you would.
Thank you very much, Eleanor. I hope my microphone is working. I can share with you immediately a personal feeling, which is most women hate armchair panels because you're dealing with glasses, water, a microphone, and papers, but we'll manage. Yes, the three cases I referred to just now were cases dealt with by the Grand Chamber of 17 judges. They were relinquished because the chambers, which were originally responsible for them, could clearly see we can't do this on our own. The highest judicial formation has to deal with them. So they relinquished all three upwards. But we have had three cases which were rejected already by single judges. The court has 4 different judicial compositions, from the Grand Chamber of 17 to chambers of 7, committees of 3, and single judges. The function of the single judge is to filter out cases which are clearly manifestly inadmissible. So there were 3 cases, 2 introduced against the United Kingdom and 1 introduced against Spain, which were rejected during the last year or so by single judges. But 6 cases were adjourned, awaiting the Grand Chamber rulings. I won't give you the details of each cases, but they are introduced against the following states: a case against Italy, 2 cases against Austria, 2 cases against Norway, and a case against Germany. All of these cases raise quite similar, of course there's variations between each case, issues to the 3 rulings I just mentioned now. They raise complaints under Articles 2, 6, 8, 13, that's the importance of effective remedies, and 14, the principle of non-discrimination. They're brought by different types of applicants, some individual litigants combined with environmental associations, or some environmental associations on their own. The reason why I mentioned the states rather than giving you the details of the names of the applicants, that one thing should be immediately noticed by you. There are 46 Council of Europe states. All the cases decided thus far, and the 6 pending, are against what you could, I think, call Western, traditional, long-established, and more prosperous democracies. There are also states in which there may be a tradition or funding for public interest litigation. That is very often an explanation of how a case comes to Strasbourg. So as a starter, that's the information I would give you in terms of our climate change docket. And when I speak about the climate change cases, I emphasize that it's very, very important to put them in context. We have 3 rulings handed down, 6 cases pending, but we have 64,000 applications. So we're not a climate change court, but we are a court before which certain climate change applications have been introduced.
President O'Leary, thank you very much for that, and thank you also for emphasizing the important points. Look at where the cases are being brought. So look at the states which have got, if you like, the legal professionals who are picking up on these points and who are bringing them before court, because courts don't decide cases out of thin air. They decide cases because the case gets brought before them. If I may turn perhaps to President Aboud, is it the experience of your jurisdiction yet that you have climate change cases, or have you had so far more environmental cases concerning the environment? What's the position, please?
Thank you. In the African court is relatively, as you know, new regional court, just over 15 years in existence. It has never or not yet been seized with the case relating to sustainability and climate change issues. The latter, however, is considered as an emerging human rights concern on the African continent. The court has, however, dealt with at least one case relating with the right to clean and satisfactory environment under Article 24 of the African Charter on Human and People's Rights, of which I will talk about it later. I will just mention it's a case of one of the human rights organizations and 2 others, as the Republic of Cote d'Ivoire, which was relating to one of the multinational company which dumped in 2006, dumped hazardous toxic waste, chemical wastes in various areas in Ivory Coast city and its suburb when it was unloaded in one of the ship in the sea. And as a result of that, many people were affected by the pollution, which was caused by the air pollution, which was caused by that unloaded toxic waste, chemical waste. And many died, others got ill, and it was long-lasting illness to many residents of the city and the suburbs of the Abidjan because of that, of inhalation of toxic gases. The court, of course, found the Ivorian government responsible that violated human rights, especially right to life and right to enjoyment of the best attainable state of physical and mental health, as well as right to a general satisfactory environment conducive to their development, and ordered reparation to the victims. Not only that, the court also ordered that the Republic of Ivory Coast should also put in place some measures or set up a regulatory framework to prevent and combat the import into its territory of toxic waste, of which the adverse impact on human rights could or should have been known. The most important or significant order of this case was one of the non-peculiar order, which was made by the court, as it is in its judgment, that the court therefore orders the respondent set to organize training courses for relevant civil servants with a view to raise their awareness of human rights and environmental protection issues, and to include these courses in schools and university curriculum. That was just to make sure that all the population, the community within Ivory Coast knows about the impact, the negative impact of pollution, of chemical toxic waste and other pollution which would affect the environment of that country.
President Aboud, thank you very much. And what you've said also is going to link forward to some of the matters we'll come to later in the discussion, not least what a court can actually say and what it can order without overstepping the bounds of what the court does versus what the legislator does. President Hernandez, if I may turn to you perhaps and ask you if you'd be so kind as to give us the picture of where things stand in your jurisdiction.
Yes, first of all, good afternoon, distinguished colleagues, esteemed guests, fellow panelists. President Barroso, it's an honor to have you here in the audience. I would like also to acknowledge Madam President Aboud and former President O'Leary, and thank the staff and Dean of IA Law School and co-president of ICONS, as well as Professor Sharpston. To address your question, in the Inter-American Court, we've had more environmental cases than sustainability and climate change cases. Today, or at this time, we're having an advisory opinion on climate change and sustainability issues. I think it's the most important case in advisory opinion in the history of the court. We've had a tremendous participation from all over the world, of all regions and generations of people. We've had 3 audiences in different parts this year, one in Barbados to listen to the impacts of the Caribbean and the insular islands, one in Manaus in Brazil, where we heard a lot of indigenous populations from Alaska to Argentina, and of course of Brazil and the Amazonias. And we had another hearing in Brasilia. We've had a participation of 265 amicus or observations. It is, I believe, it's the most participative process in the history of the court. Last year, we had a very interesting case. It's not technically a climate change case, but it's a very important case called La Oroya versus Peru. It is the strongest decision and most comprehensive judgment of the Inter-American Court regarding environmental issues. La Oroya is a town, a city in Peru, about 30,000 people. It was classified in 2006 as one of the 10 most contaminated cities in the planet. The court found that Peru was internationally responsible for human rights violations affecting 80 inhabitants, but rendered reparations to the whole community. These violations resulted from air, water, and soil pollution caused by mining and metallurgical activities at the Oroya Metallurgical Company and the state's failure to regulate, supervise these activities. The court highlighted that these actions and omissions violated the victim's right to a healthy environment, health, life, and personal integrity. In this case, it was proven, for example, that 99.9% of the children under 6 years of age had dangerous high blood levels of lead. The Ministry of Health linked high air pollution from metallurgical facilities to respiratory and cardiovascular problems. In 2017, a study found that emissions of over 87 years of contaminated high metal pollutions contaminated 2,300 square kilometers of soil, with lead levels exceeding permissible limits by 87% of lead. Also in the Mantanaro River, rendering water unsuitable for aquatic life, irrigation, and drinking. And I believe that one of the most important standards of this case is that given the difficulty of establishing scientific causality between the pollution and the illnesses of the people, some died of cancer, some still have cancer and other illnesses, the court said it is not necessary to demonstrate that direct cause of exposure to metals is the cause of the disease, because the exposure to such high contaminants of pollutants and heavy metals is enough risk to compromise life, integrity, and the health of the inhabitants. The other environmental cases the court had in the beginning were more directed of indigenous people and their territories and the protection of their natural resources against mining, pollution, and exploitation. And we also had a very important advisory opinion number 23, where the court declared the environment as an autonomous right. So we've had a lot of litigation regarding environment, and now we're starting the same path as other courts. We're being required this time with advisory opinion on climate change. And now we are seeing a new phenomenon in the court, is that not only victims are coming to the court, but are the states that are coming to the court for answers on these issues.
Thank you very much for that, because you have already highlighted some very important points. One being the point on causality and risk, and whether at a certain level of risk you almost see the causality must come from it. But also you lead very neatly onto the next question that I wanted to raise with you, which was who can bring the case? Who has locus standi to bring the action? Does the individual? Is there an association of claimants, a non-governmental organization? What about the actio popularis? What about all of that? Because a big question for lawyers, before we get to the substance of the action, is who can get in through the door of the court. Now, President O'Leary, you've already told us very helpfully a certain amount about that in relation to the three climate changes cases you've discussed. And so we know that there isn't an actio popularis under the convention, and we know that perhaps the innovation lay in the situation of the association. With your permission, I'm in a sense going to say you've made your contribution on this point, give you a chance to rest your voice and have a glass of water, while I turn to our other two colleagues here and ask President Aboud perhaps if you have a point or a view on that you'd like to share with us. Who can get in through the door of the court?
According to the protocol establishing the court, we have at least 3 entities or 4 who have direct access to the court. The first being the African Commission on Human and People's Rights. Then the second one is state parties to the protocol establishing the court, African Intergovernmental Organization, and individuals or NGOs who have observer status before the African Commission on Human and People's Rights. Those are the ones who can access direct the African courts, as long as the state party against which they are complaining has deposited the declaration under Article 34, sub 6 of the protocol, that is the protocol establishing the court, to allow the courts to receive the application and determine them. The court has also adopted an action to pluralities approach. and does not insist on the legal interests of the applicant or the victim requirement. However, the applicant must show proof that they have been authorized by the victims, to come up with the matter before the court through, among others, means like power of attorney or affidavit. That's the only requirement. Yeah.
Thank you. President Hernandez, what about your court?
Well, in the inter-American system, in the contentious cases, only natural persons have standing before the court, not legal entities, with two exceptions: indigenous populations and unions. But victims or persons can be represented by NGOs and other organizations and are commonly represented by these groups. In the advisory opinion jurisdiction, it's very broad. All the member states of the OAS or any of its organs can request an interpretation of the American Convention or other treaties with human rights implications, and that is not only the 20 states that recognize the court's jurisdiction, but all members of the OAS that I believe are at 34 at this time. And also, if in a contentious case, a group of people like in La Oroya need to regroup and they don't have means, they need to act as a group, they can. And if they don't have representation, the system has two important aids. It has a legal fund for the victims that the court administrates, and it has and they have access to a public defender, inter-American public defender that can also represent them freely. I believe this helps a lot the access to justice of many groups that even if they have to act individually and not as a group, they can have better access to judges with this type of aids. But we don't have actio popularis like the African court.
Thank you. I want to move on from there to ask the question to which the answer may be a very simple one. What can the case be brought about? I have in mind an article, a very famous article, a long time ago, called "Do Trees Have Rights?" And I know that for some people who are more activist in environmental protection and in the fight against climate change, the question naturally arises, well, you know, who can speak on behalf of the trees? Who can speak on behalf of the rivers, of the fish? Indigenous people cases come into mind in this context. But I want to know from you, or I'd be helped to know from you, does the claim have to be formed, have to be framed in terms of here is a human right that is being violated, or is there any scope for saying I can't identify a human right, but yes, there should be a right for the trees or for the fish? I think I know the answer in relation to the ECHR, but President O'Leary, over to you.
Thank you very much. If I could start with a tiny postscript on access to court and the question of locus standi,
yes,
and because President Hernandez has emphasized that the Inter-American Court has both contentious and non-contentious proceedings, and the European Court of Human Rights since 2018 has the same. We have a new protocol, Protocol 16, which allows designated courts in states which have ratified the protocol to request an advisory opinion. I think I have my figures correct when I say that in this time we've rejected 3 requests and we have handed down 6 advisory opinions. Legal folklore has it that the Dutch court, which handed down Urgenda, which was really the first European national climate change judgment, was toying around with the idea of asking for an advisory opinion from the European Court of Human Rights on the Convention on Climate Change. I think now that I'm a former president, I can say that it's with great relief that we noticed that they took the decision themselves and didn't decide to use Protocol 16 and a non-contentious proceeding which had never been tested in order to ask for that advisory opinion. That's not to say advisory opinions won't or shouldn't come, but we're developing the protocol, or we were, and so Urgenda was decided at national level, and the cases we're dealing with are contentious cases. As regards your question regarding who can invoke rights and are they human rights? The answer from Europe's regional human rights court is it is a human rights convention. And so not only do we have the statement in Klima, which is in accordance with our existing jurisprudence that the convention, no article of the convention is specifically designed to give general protection of the environment, but you also see very clear statements in Klima, for example, paragraph 463, whether the victim is direct, indirect, or potential, there must be a link between the applicant, person, and the harm. And if you go through the judgment, you will see that restriction of protection of human rights throughout the judgment. However, when Professor Sharpston kindly gave us sight of some of her questions, I thought about a recent judgment called Executif van de Muslim van België and others against Belgium. This is a case about ritual slaughter, a question which came both to the Court of Justice of the European Union and to the European Convention on Human Rights Court. And there the court explained that the living instrument document, which guides the interpretation of the convention, concerns not only the rights and freedoms that are guaranteed, but also the grounds justifying any restrictions. And they found in that case that animal welfare can be attached to public morals. So you can protect the environment under the justification stage, but the rights are the rights of human beings, and they are the rights of those who are directly, indirectly, or potentially affected.
I'm really grateful to you both for adding the additional information about the recent protocol and the advisory jurisdiction, but also particular for mentioning the ritual slaughter cases, because that is an interesting development of protection, both in the Court of Justice, the European Union's case law, in adding animal welfare in, and indeed giving animal welfare, one might almost say, a higher status than religious ritual observance. And you're adding in your case law of your court, adding in the animal welfare. If I may perhaps turn to you, President Aboud, what about your court? Is it very much, it's based on identifying the human right which may be being jeopardized? Is there any scope for looking more widely?
In our court is very clear, according to the protocol establishing the court, that the material jurisdiction of the court relates to allegations, alleged violation of human or individual rights only. In our position, it will be very difficult to go out of what we have been mandated. And I've listened very well from my sister and from her sister, former president of the European Court. And I read her keynote speech, of which you can see there's a very different jurisdiction between their court and ours. Ours, the mandate is so limited, we cannot go beyond what we have been mandated by the protocol. So on this issue, I cannot say anything. Yeah.
Right. President Hernandez.
Well, at this stage, it is not possible to bring claims for non-human actors in our court, but that doesn't mean that the several aspects of the environment don't have protection. And it is because in advisory opinion number 23, the court stated that the right to healthy environment is an autonomous right, and this right, unlike other rights, protects the components of the environment, such as the forests, the rivers, the seas, and et cetera, even though they don't pose any risk to individuals. This means that it protects nature and the environment, not only because the benefits they provide to humanity or the effects of their degradation may have on other human rights as health and life, etc., or personal integrity, but because of their importance to other living organisms which we share the planet and that also merit protection on their own. So the case may not start as a petition for the trees or the forest, but that doesn't mean that they don't have protection in the Inter-American Court of Human Rights, according to this opinion and further cases that have been developed in the court.
Right. I want to move on from there, if we may, to the relationship between the national court structure and the role of the regional court. You, all three of you, as presidents of regional courts. And I was wondering whether it's a common factor or not that it's necessary, before you get to the regional court, it is necessary to go through the court structure in the country concerned and all the way through before you go to the regional court, what is called in shorthand an exhaustion of rights doctrine and the exhaustion of domestic remedies. And of course, the reasons behind that rule are multiple and sensible, but perhaps one can single out two, that if you have the regional structure, there should be an opportunity for the national system to sort out the problem, the subsidiarity application within the European Court of Human Rights. And also, of course, that a court trying to decide a case has to have a factual basis for its deliberation. You have to know what was going on and know clearly enough, because otherwise you can't tell where your reasoning is going to take you. And so I was wondering perhaps if you would address that briefly, President O'Leary, and then I will turn to your two sisters.
Thank you very much. You've skillfully explained how the convention system works. It's a system fundamentally based on subsidiarity. So the primary responsibility is for the national authorities, including the national courts. The whole purpose of the system is that cases don't get to Strasbourg. And it's not that the Strasbourg court is touting for work. As you heard me earlier, I'm doing quite the opposite. It's fundamentally important that domestic remedies are exhausted, and Professor Sharpston has emphasized why. And we see this at work concretely in the Portuguese case in Duarte. I'd invite you to look at paragraphs 226 to 228, because then the court basically encapsulated the reasoning behind the exhaustion rule. First of all, domestic courts have to be given an opportunity to make right what the applicants are claiming is not working properly. An international court shouldn't be able to find the state in violation of international law without the national authorities and the national courts having had the opportunity to put things right first. But secondly, the court emphasized what Eleanor has just said. Had the applicants in Duarte gone before the Portuguese courts, then the court in Strasbourg would, and I quote, have had the benefit of the factual and legal findings and the assessment of the national courts. And in cases relating to Article 8, for example, qualified rights, this is really important, because the court needs to see how the national courts have balanced the competing rights and interests. The other thing that the court stressed, and it does this regularly, is that the Strasbourg court doesn't have the capacity, nor is it appropriate, given its function as an international subsidiary court, to adjudicate on large numbers of cases which require the finding of basic facts. And so the Duarte case fell on the failure to exhaust what the court regarded as effective Portuguese remedies. Portugal had territorial jurisdiction, and the court emphasized that the Strasbourg court can't really establish whether an applicant, an individual applicant, has met the high threshold test for individual victim status if the national courts haven't actually worked through the different issues which would be relevant to the court analyzing the two-step test, which was set down in the Klima judgment. But Duarte is just one recent example of many important cases where even the Grand Chamber of the court has emphasized please exhaust your remedies. We're only here as a last resort. The less cases that come to Strasbourg, the better the convention system is functioning.
Thank you very much. President Aboud, do I have to exhaust my domestic remedies before I come to your court?
Yes, exactly. It's a requirement under Article 56 of the African Charter, which anyone who wants to come before the African court must adhere to rigorous admissibility requirements. And exhaustion of local remedies is one of them, that you have to exhaust the local remedies. And as my sister said, this is just to give the opportunity to the member states of the African Union, who are the parties to the court, to resolve the matter at the national level before they drag their cases or their complaint to the international arena, that to the African court. However, there is an exception within the same charter as well as the protocol, that anyone is allowed to come direct to the court before exhaustion of local remedies if he or she can demonstrate that the domestic remedies are not available, or they are ineffective, or are unduly prolonged. Then they can come direct to the court, and the court can consider that after they have satisfied with what have submitted by him, that all those elements are there.
Thank you. I have a recollection, but you'll correct me if I'm wrong, President O'Leary, that in the jurisprudence of your court, I am required to exhaust remedies, but I'm not required to do the absolutely impossible. If it is clear that there is no point at all in my trying to go to a further court, because I'm only going to be turned down, from the case law, domestic case law so far, it's evident I can't go further. I believe I'm not required to spend the time and the money to try that remedy so that I can then tick the box and say, yes, I tried. But am I right in my recollection?
You are right, but I would say that the exhaustion requirement has been applied more strictly in recent years, in accordance with what is a very considerable commitment to the underlying principle of subsidiarity. As President Aboud said, you're not required to exhaust ineffective domestic remedies, or if there is no remedy, but your lawyer, or you yourself, shouldn't speculate and presume you will fail. You will be expected to try. A very good example of that actually came from the UK in relation to what's called the gay cake case from Belfast, where the applicant had gone all the way through the UK system, including up to the UK Supreme Court, but had never relied on convention arguments, had relied in substance. And the court was very strict in that case. We had also another Swiss case involving COVID measures, because the trade union in Switzerland had not gone before the courts because they said, we're doomed to fail. And the court in Strasbourg at Grand Chamber level said, you should have tried. This was a global pandemic, the first of its nature in 100 years. You had to try your remedies before the Swiss courts, because in that case, what was precisely at issue was the balancing of different a right and other general interests.
The warning for those of us who are both academics and practitioners, don't be too sure of your estimate as to whether you're doomed to failure. It is better to demonstrate that you tried and failed to be quite sure that you did exhaust your remedies. But President Hernandez, what about your jurisdiction, please?
We have the similarity of the exhaustion rule. In the same cases, you can have an exception if the remedy is not effective or is inexistent, or in other cases. But we have an additional step that does not have the European court, and I don't know if the African court, and is that the case has to be first surrendered to the Inter-American Commission, that itself determines the admissibility and merits of the case before sending it to the Inter-American Court. So we have all these other steps to get to the court.
Right. I mean, of course, flowing from that, there is obviously the question of time, how long anything takes. If you work your way fully through the domestic legal system, then you go to the regional court. I've always been deeply impressed by the workload and the docket length of your court, President O'Leary. And I know that you've made heroic efforts to deal with that. But nevertheless, there is a time factor there. I have no sense at all of how long a case takes before either of your courts, in terms of, once I've exhausted my domestic remedies and I bring the case before you. I mean, obviously it's going to be variable, but what kind of time scale are we talking about? President Aboud.
Yeah, according to the rules, the court rules, the matter should be within the court for 12 months. But practically, that has not been the case. And the cause of that delay is not there. Sometimes it's not the court, it's the parties themselves.
Sure.
When they delay to submit some, to file their submissions on time, and sometimes they seek extension to refile, new submissions and so many things. And the African court, being the human rights court, we normally consider if we are satisfied. The reason given, in order to do justice, we give extension of time. So most of the cases, they take more than 12 months, but others, they take less than that. It all depends on the circumstance of the case.
I'm very impressed at the 12 months, President Wood, I have to say. That's possibly having spent 14 and a half years working in the Court of Justice of the European Union, where we got mesmerized by our judicial statistics and how bad they looked, particularly in respect of cases that got referred from national courts. And we tried desperately to get the time down. There was a bad stage when those cases were averaging. Obviously, all averages are misleading, but the worst early 2002, 2003, those cases were running at 26 months turnaround time. And one of the things that happened when the court got more judges was that we really slashed the time. It's now running, I think, at about 14, 15 months. So when you say 12 months, I am deeply impressed. President Hernandez, what about your court?
Well, I'm ashamed to say a lot more than 12 months.
I feel reassured. Please.
Well, as I said in my previous answer, the court gets the cases from the Commission, and the Commission has to make an admissibility and merit report, and that could take many decades, like 10 or 12 years before sometimes 15 years before the case comes to the court. Once it is in the Inter-American Court, the cases take about 2 years, but that is in the contentious jurisdiction. We have a real-time justice in advisory opinions, like 1 or 2 years to render the opinion. They come directly to the court, and we have another function that is very, very important, that is the capacity to dictate provisional measures that are immediate in cases that are urgent and that can have irreparable harm. And the court has, at the moment, about 34 of these measures. One of them that is a very important case that we're working with the Brazilian authorities, that is in favor of the Yanomami people in the Amazonian region. So those are immediate, like months, 2 months or so.
Right. But the availability of interim relief is obviously a very important question at a practical level, and also something that helps to palliate the problems of inevitable delay if there is a lot of work in the court's docket. I want to move across from there because we've seen that you can't bring a case to protect, as it were, the forest's rights or the rights of the wildlife, the rights of the bird, the rights of the fish, the rights of the tree, which leads me obviously to ask the question, all right, which particular human rights are capable then of being invoked in order to mount litigation which is aimed at combating climate change? And we've seen this a little bit already from our keynote speech in terms of Article 2 and Article 8. Article 2 on the right to life, Article 8, the right to private life, the right of access to the court. I mean, what does the shopping list look like, or does that depend on the inventiveness of the lawyers who formulate the cases, President O'Leary?
Based on the cases that we've already decided or the cases that we've seen adjourned, it's Article 2, right to life, Article 3, prohibition of inhumane and degrading treatment, Article 6, access to court, 8, private life and home life, 13, which is about effective remedies, it's an article that can't function on its own, and 14, another article which doesn't function on its own, on the right not to be discriminated against. Article 1 of Protocol 1 is the right to property, is another possibility. And when thinking about this before we came here today, if climate change infringements under domestic law result in criminal charges and convictions, then you may see things like Article 5 or even Article 7. The convention is almost 75 years of age. We've handed down over 1 million, we've dealt with over 1 million cases, and I think the judgments are well beyond 27,000 now. It's very elastic. The lawyers will mold their complaints in accordance with the terms of domestic law, and then the evolving case law of the European Court. That's essentially how it will operate. But it's very likely that the core analysis will be 2, 6, and 8. And if you look at the cases which were handed down by national courts, cases which never came to Strasbourg, so Urgenda, Friends of the Irish Environment, Neubauer, there's a case pending before the Belgian Court of Appeal, I think, because it comes from the Belgian Court of Appeal in Klimaatzaak, I think it's called. All of these cases are invoking those articles or equivalent constitutional provisions. But there are very different routes to climate change litigation. Human rights is just one route. Tort law is another. Constitutional law was the basis in Germany. Statutory law was the basis for Friends of the Irish Environment. So I always emphasize all roads do not and should not lead to Strasbourg. That's just one strand of litigation in relation to climate change.
But also a very important point you make there, that this is it's an interwoven garment. There are different strands, and depending on the circumstances of what you're looking at, a particular route may be appropriate, a different route may be curious and interesting, but actually not going to work. And I mean, surely this is one of the richnesses of public law, trying to work out, as public law evolves and develops, how different arguments and different concepts get accommodated. I'm going to turn to President Aboud and say, within your jurisdiction, the way you can see these cases being formulated, would it line up with the same sort of rights that President O'Leary was enumerating just now, a right to life, a right to privacy, right of access to the courts? What's your feeling on this?
Yeah, I think I would agree with my sister that the human rights that would be involved would be the right to life, as said, right to health, right to property, right to clean and satisfactory environment, right to food, freedom of movement. These, in my opinion, and according to our jurisdiction, I think these are some of the rights that are mostly likely to be affected when the nature is interfered with or not protected.
Right. President Hernandez.
Well, the same rights that have been mentioned, depending on the nature of the case, life integrity, and sometimes freedom of expression, access to information, etc. But the court has also, as I mentioned, since 2017 in Lagos del Campo, the court has ruled it has jurisdiction to declare autonomous violations of economical, social, and cultural rights and environmental rights derived from the protection of Article 26 of the Convention. So that opens a whole scope of social rights for the court that can also be litigated in these issues in the court, besides the ones that have been mentioned.
Right. Now, the next, trying to move on from there, but it's very much associated with what the three of you have just been saying, and it's almost a philosophical question. It's the extent to which your existing case law would have to, and I'm putting quotes around this word, develop, right? In order to accommodate a claim based on one of those human rights, which was brought in the context of sustainability, in the context of combating climate change. And I'm very conscious of the fact that whether case law has to develop or whether it's just a natural application of existing case law may be rather in the eye of the beholder. I'm also conscious of the fact that in the Klima Senioren cases, my compatriot was your dissenting judge in relation to some of your court's findings. But President O'Leary, would you like to have a go at that one?
It's probably easier for me to respond to this question than President Hernandez, because she's in the difficult position of being an pending advisory opinion. So I'll take the hit on your behalf.
Thank you.
I was intending to allow President Hernandez to sit out this particular round, please.
And in the notes that I sent to you, I did indeed respond in precisely that way. The answer to this question seems to be in the eye of the beholder. For many commentators on the recent Klima and judgment and the other judgments, except for the extension of standing in relation to the association, which I think everyone accepts, this was a development under the living instrument doctrine. Looking at the rest of the elements in the three rulings, 2 inadmissibility decisions and 1 judgment finding 2 violations of 6 and 8. And this is what I, of course, emphasized in my keynote. I think you are generally looking at convention orthodoxy, albeit in a new context, in the context of climate change litigation. And I stress that in relation to application of the exhaustion rule, the importance of subsidiarity. Look at the extensive engagement in the preliminary observations, identifying the importance of separation of powers, the constraints on the role of judges on this field, the emphasis on the primary responsibility being on domestic executives and legislatures. And if you look at the Article 8 positive obligation, where the court was more detailed in relation to the mitigation measures that it would look for, essentially, if you boil it all down, it comes out as a due diligence obligation, which is a reflection of 40 years of environmental case law. But there are people who see things differently. The sole dissenting judge, Judge Eike, in the Klima case, the recent very unhappy majority in the Swiss House of Representatives, or the former UK Energy Secretary, who, within hours of the judgment having been delivered, declared that we had trespassed into the domain of democratic decision makers. And I don't usually use props, but I'm going to on this occasion. But if she could read that in detail in a few hours, or if her advisors did, she's a faster speed reader than I am. And I've been president of a court with 64,000 cases. So when I read the critics, and as I said to you, the critics are really important to judges, former and sitting, because it's really important to see what was understood, misunderstood, what needs further clarification. But I can often, having lived these judgments for a very long time, the deliberation process, I thought, but they haven't read paragraph 503. They haven't looked at paragraph 600. It's a long judgment, and it's a long judgment for a reason. There were 37 third-party interventions in the case across the 3 cases. We had in the Duarte case, Portugal plus 32 other respondent states. One of them was Ukraine, which then was excluded because the applicants withdrew their case. The other was the Russian Federation, which was expelled from the Council of Europe, but in relation to which we retain a jurisdiction. So criticism is fantastic, but as long as it's balanced. Judgments should be balanced, but so should criticism of judgments, well-informed and balanced. There are some who are delighted with the rulings. There are some who are not delighted with the rulings. But this is a story that has still to run. The general principles on some issues have been set down. Now they have to be applied. First and foremost, they have to be applied by national judges. And then the cases will come to us. And on verra.
President Aboud,
Yeah.
would you like to have a go at this one? What do you feel? Developing case law, extending case law, staying within the case law but putting it in a new context? Have you a feeling about this?
On the part of the African Court, I would say its jurisprudence is still very young compared to my 2 sisters' courts. However, we have been inspired, and most part, we do adopt the well-established jurisprudence of our sister courts, that's Inter-American courts and the European courts, as well as the UN Human Rights Treaties body to develop our jurisprudence. However, in doing so, the courts also do take recognizance of the peculiarity of the African continent. We do not just adopt that, we have to take that the peculiarity of our continent. I do believe the court's jurisprudence, that is the African courts, will develop based on the cases that come before it, the development in the human rights discourse, and the realities of the continent. That's our position. Yeah.
I mean, if I may offer a contribution from the court in which I used to serve, I think some of it really is in the eye of the beholder, and I'm going to give the most obvious and classic example, which is the factor-tame litigation, and whether the court there was doing something incredibly innovative. For reference, the factor-tame cases arose out of the United Kingdom's decision that it didn't want Spanish fishermen, it didn't want Spanish fishermen fishing against the UK quota. And so it introduced the Merchant Shipping Act. And in that act, it made very strict rules about which vessels were able to register under the British flag and were therefore able to fish British fish. Right? I mean, the fish did not have Union Jacks painted on the side, okay? But nevertheless, they were considered to be British fish, and since they were loyal and patriotic fish, they obviously would not wish to get into a net that belonged to anyone except a British fisherman. History does not relate whether the government took evidence from the fish before it legislated on this point. However, the difficulty for the applicants who were claiming rights under EU law, were claiming freedom of establishment, that they should be able to register, to establish their companies in and fish against the British quota. The difficulty was that the UK government had absolutely deliberately introduced this new measure by way of Act of Parliament. And under national law, the courts have a reverence for Parliament, which means that it is totally unthinkable that you would issue interim relief against an act of parliament, to suspend an act of parliament. So with very brave counsel, David Vaughan and his friends, the reference came from the House of Lords to the court in Luxembourg. And it really depended on how you rewrote the questions that had been sent by the House of Lords. The questions were very, very British-style drafting and completely incomprehensible if you were not a highly experienced English common lawyer. They were a bit like a Gothic cathedral, you know, beautiful to admire, but don't try to work out which rib of stone is holding up the roof. And so you had to rewrite the questions. But the key issue was, how do you rewrite the questions? If you rewrote the questions as being, do you create a new remedy under EEC law? A new remedy which is suspending an act of parliament? That would have been an extraordinarily bold and innovative step, and one which really would have been difficult to reconcile with the existing case law, because the existing case law said you don't create new remedies, you apply within the legal structure your remedies are remedies under national law, subject to non-discrimination and effectiveness. That was one way of doing the rewrite, but the other way of doing the rewrite was much more promising. If there was just a little rule of national law, like you cannot get injunctive relief against the Crown, well, I mean, there was lots of case law that said you disapply that tiny little rule of national law. And indeed, very recently in the chronology of the time, in the Siementhal case, the court had done exactly that. So, not being innovative at all, you rewrite the question. You say, look what we said already in Siementhal. Naturally, the national judge should disapply this little rule of national law. It acquired quite a lot of comments within the United Kingdom when that judgment came down. Anyway, that was a small, just as an illustration of obviously a different area, but nevertheless, I think it does illustrate the point that what is innovative or what is an orthodox application of the case law does depend very much on your perspective. I'm going to mention the practitioner's word, which is costs. What about the costs of litigating? I raise this partly because I serve as a member of the Aarhus Convention Compliance Committee, and we're quite interested in costs because we bear in mind that Article 9.1, second paragraph of the Aarhus Convention says that in the circumstances where a party provides for review by a court of law, it shall ensure that such a person also has access to an expeditious procedure established by law that is free of charge or inexpensive for reconsideration by a public authority or review by an independent and impartial body other than the court of law. So it mustn't cost the earth to litigate to protect the earth would be the soundbite slogan. But what about costs? What about the costs of litigating?
What's interesting in the Strasbourg climate change docket is, of course, as you saw in the Klima case, they weren't just individual applicants, there was also an environmental association. And this is reflected across the cases which were rejected by the single judges. The two UK cases and the Spanish case involved non-profit or non-governmental organizations. Several of the adjourned and pending cases also involve an association. As regards your reference to the Aarhus Convention, which was referenced by the court in the Klima judgment, 27 of the 46 high contracting parties to the convention are also EU member states. So I think the answer for those states is this could be a question of EU law, because EU law has transposed the Aarhus Convention via different pieces of secondary legislation. For the remainder of Council of Europe states, cost difficulties usually manifest themselves in the form of an Article 6 access to court issue. But I think that's not going to be the first type of question that arises. And as I said when I explained the provenance of the pending cases, they come from states where financing or funding of public interest litigation is clearly present and possible, or where legal costs are low. This is another issue.
President Aboud, what about your court? Cost of coming to bring a case before you?
In fact, according to the charter as well as the protocol, no cost. In case you want to bring any case, there's no any cost.
Okay.
Yeah. There's no any cost to bring any case before the court. And then sometimes even the cost to bring representative for the applicant, they are bared by the court, by the legal aid fund, which has been created by the African Union. So, you know, the issue of cost is not there in our court.
Right.
Yeah.
And President Hernandez?
Well, we don't have the Aarhus Convention, but in our region, there's the Escazú Agreement that I believe has a similar norm for technical and legal assistance, but that would be on the domestic level. As I said before the court, it would depend on the nature of the case, how many victims, et cetera, et cetera. So, but the court has, as I said, a legal fund for access to justice for the ones who cannot afford coming to the court, et cetera, and also available inter-American public defender.
Right.
But I guess that if it is in a contentious case and you have to wait or litigate 10, 15, or 20 years, it's going to be expensive.
Right. I'm conscious of the fact, I mean, there's lots of questions that a curious academic can ask, but I'm also conscious of the fact that we're meant to have a time frame for this. So I'm going to ask what could be an enormous question, but I'm going to invite my three presidents to decide how far they take the answer. And it's a question in relation to what the court feels that it can order and what about compliance. Now, I put it in that very loose way because one of the things that struck me in a very good way about the Klima case was that your court, President O'Leary, was very careful. It found the violation, but it didn't tell the Swiss what they were meant to do, right? And you distinguish between the various breadths of the margin of appreciation that is left for the contracting state. And I was going to ask you, perhaps, if you want to, just to expand a little bit on that, so we get a kind of better feel for it, and so that perhaps can serve as a springboard for President Aboud and President Hernandez to then comment further.
Thank you very much. I'll make a distinction between questions of what are called Article 46 indications under the Convention. The court can indicate individual or general measures that a respondent state found in violation should adopt, and more general questions of compliance and execution. As regards, when it came to Article 46, the applicants had requested that the court indicate measures, and it declined to do so, as Professor Sharpston just indicated at the end of the judgment. And this was quite simply because of the nature of the Article 8 positive obligation of due diligence, which had been identified, but also because of the differentiated margin of appreciation and the fact that when it comes to the choice of means, how you comply with your Article 8 positive obligations, the states had been left a wide margin of appreciation. So the court did not start telling the Swiss government, those primarily responsible for complying with the convention, this is what you now must do. I should stress that many judges feel more or less comfortable, depending on their legal professional background or their own national legal system, with Article 46 measures generally. For some judges, this is not terrain where they feel very comfortable. Others think it's quite fine. So there were no general measures indicated under Article 46, and I'm glad that you approve. I think it's a further, what I called modulators in the keynote. It's an explanation of the court's consciousness of its complementary role, its subsidiary role, and the constraints on judges in a context of this nature. The more broader question is the question of compliance and execution. The court isn't responsible for the execution of its own judgments. I think that's one of the differences that we have in our systems. It is the Committee of Ministers of the Council of Europe which is responsible for execution and which will now have to follow up with the Swiss authorities. As regards the broader question of compliance, of course the reaction politically in some quarters in Switzerland shows you the difficulties that a regional human rights court and international law generally encounters in 2024. Because the debate in the House of Representatives, I think, was extremely heated. I can't read some of the Swiss press, but I had a fair insight into what was going on. And the House of Representatives voted by a majority, essentially, that they didn't want to execute the judgment. But they're not the only authority in Switzerland. It will be for the Committee of Ministers to engage with the respondent government. And I should add, I think a sign of a green shoot, which I always think is important to stress in this day and age, the new Secretary General of the Council of Europe is a former Swiss minister. And in his first speech as the Secretary General-elect, he emphasized the requirement on all states, whether the Russian Federation, a former high contracting party, to the United Kingdom, to Ireland, Spain, Iceland, and Switzerland. You have signed up to this convention. These are your international legal obligations. Now you engage in the process with the Committee of Ministers. But thankfully, my job as presiding judge is done, and I will watch with great interest from afar.
President Aboud, your position of your court, the same, different? You've heard that very helpful and nuanced expansion on my rather loose question from President O'Leary. What about your court on indicating specific measures and/or the general question of who follows up on compliance with your judgments?
Yeah, as well said by the previous speaker, we have, that's on the issue of execution first. Let me start with that. I think we differ with the European Court because the African Court doesn't have, responsibility or powers for executions or to enforce executions of its own decisions. That power has been given to the Executive Council of the African Union, according to protocol establishing the court, that is Article 2029. The only responsibility we have as a court is to submit the report showing the status of execution after we got the report from the responsible states. At what level they have, or to what extent they have executed, because we normally, under our compliance monitoring units, we ask the state parties to what extent have they complied to our decisions and in terms of execution. And then they give us the feedback, which we include in our reports, telling the Executive Council that, State X didn't comply to our decisions. To date, no aid execution that has been done. But we don't have any power to make sure that our decisions are executed or complied with, which is different from the European Union Court. And that has been a very big challenge to us, because any court, you would like to see, your decision have been complied. Sure. Otherwise, it's as if you haven't done anything. For many years, you give decisions, they're not complied. To date, I would just want to share with you, it's only 10% of our decisions that have been complied, and out of 10, 7 have been complied partially, and only 3 fully complied with it. So you can imagine Sometimes it is so frustrating, but we are there to serve Africans, and we are still struggling to make sure that some mechanisms are established. We have sent our proposal to the African Union Commission so that can be tabled before the African Union Summit of Leaders to make decision on how to change, the current, system, or either to amend the protocol to allow a workable or viable mechanism to make sure that the decisions of the African Court are complied with and are executed fully. So we have that big challenge.
No, that is indeed a big challenge.
Yep.
And all credit to you and your colleagues for nevertheless doing your work correctly and thoroughly and being optimistic, nevertheless, about where you're going. Maybe not where you've got to already, but where you're going. President Hernandez.
Well, I believe that's a question for another panel. It's a very big question and a very complex one. The Inter-American Court also has has an office for the compliance of the sentences, but the Inter-American system has a very different reparations means. It has more than economic measures. It has non-repetition measures that require sometimes to change a constitution or legislation or a public policy. And since environmental omissions or violations in this case many are because of structural issues, some remedies are going to take longer than others. So taking as an example the indigenous cases, lately we have seen advances in economic reparations from some states, and in other cases where they have to delimitar, how to say, the land, it takes many, many years for that to happen. But lately we had a case in Argentina that was for a decade had no advance, and now they acquire funding to do that 400 acres delimitation, and they are advancing. So it depends on the structural omission and the will of the state, because it happens a lot in our region that some states are more willing to comply than others, or it takes a change of government so that the cases can advance or not. So it is a very complex issue, and we also have challenges on those aspects.
As you so rightly say, it is a subject which we could use a complete further panel just to deal with that. Yeah. Ladies and gentlemen, I hope you will agree with me that this has been a truly interesting discussion between three fine presidents speaking from their experience and sharing that experience with us. I have learned a great deal, and I felt very honored to be invited to moderate this discussion. Would you please join me in showing your appreciation of our three panelists? Well done, everyone. Well done.
Thank you all. I'm going to stand here just for a second. I don't want to turn my back on our distinguished speakers. Thank you again, President Abud, Hernandez, and O'Leary, and thank you, Advocate General Sharpston, for your masterful moderation of this panel. We are done for the day, but as I said before, there's a cocktail waiting for us upstairs on the esplanade right in front of the main entrance to the AI Tower. Formally, the cocktail does not start at 8 p.m., but you can all go there and there will be drinks already, so no worries about that. There's basically three ways to reach the venue. You can take the elevators, but there's only few of them, so if that's your choice, just be patient. I think it'll be fine, but there will be a line. You can also take the stairs, of course. It's 4 floors, so it's feasible if you're in good shape. If you really need to stretch your legs, you can also walk out of the building and then go all the way around, and our students will be there to help you. Thank you so much, and please enjoy the rest of the evening.